Welcome, everyone, to Secret Sauce, the show where we hear real-time insights from commercial real estate industry leaders. I'm Karly Iacono. Today, I am so pleased to be joined by Scott Fleischer, Counsel at Barclay Damon. Scott, welcome to the show. How are you today?
Thank you, Karly. Really appreciate it. Doing great.
Wonderful. We are extremely pleased to have you here to talk about a really important topic in commercial real estate, and that is bankruptcy, retail bankruptcies specifically, and what to do if you're a landlord who might be facing a bankruptcy of one of your tenants. So before we get into the meat of today's episode, let's step back for just a minute and tell us a bit about Barclay Damon and your role there.
Sure, I'd love to. Thanks so much. So Barclay Damon's a nearly 300 attorney firm. We have offices throughout the Northeast and in Toronto as well. So our major markets, where I'm in one of them, New York City, Boston, New Haven, Connecticut. And then we have offices throughout New York State, Syracuse, Albany, Buffalo, Rochester. It's pretty much every practice area you can imagine. I focus on bankruptcy and restructuring, and my team specifically deals with a lot of retail bankruptcy cases. And then within that, we represent landlords, and actually usually groups of landlords in a particular retail or restaurant bankruptcy case. And we have a newsletter dedicated to this topic, specifically bankruptcy basics for retail landlords. So sort of shows our niche expertise right there. And we advise many other constituents as well, but that's my focus, probably 90% of my practice.
Very important topic. We usually save this for the end, but since you just brought it up, how would someone find this newsletter? Do they reach out to you directly? Can they subscribe online? Where do they find the information?
Sure, you could find it on my bio. It's under the publications section, or if you look at the Barclay Damon website, publications, they'll all be listed there. We have gone through 18 issues already, which has been a nice process of sort of refreshing everyone on discrete topics. And we try to keep them pretty short. They're all under probably 750 words, so they're maybe like a 5-minute read. And they're just great quick hitters in case you want to find out more or refresh yourself on just a particular subtopic.
Okay, wonderful. Good resource. We'll make sure to share the link in the show notes as well.
Thank you.
All right, let's jump into the meat of today's episode. We're going right for it. What should landlords do if they hear that one of their tenants is contemplating filing Chapter 11 or maybe has already filed? What's their next step?
Yeah, absolutely. So if a retailer is maybe going to file, right, they've been in the news, you hear they're not doing well, they haven't been paying rent in a little bit. It's a very property specific or an tenant specific approach, right? If it's a center where you're dying to get a redevelopment done and they're the last holdout and you really want them to leave, then you be aggressive at that point, right? Start sending default notices as soon as you can. Maybe sue them, try to get possession of the space right away before a bankruptcy possibly hits. Because once it does hit, you'll most likely lose that ability. So if you can, get that tenant out, if that's the goal, great. Maybe you engage in negotiations and do a lease termination. That's happened in a lot of instances, with clients of ours. They've approached us saying, this tenant sort of headed down a bad path. We really want this space back. Can you help us figure out how to get out of it and still be okay from a pre-bankruptcy perspective? So that's one option. Another option could be you just leave things alone and hope they make it, right? It could be a tenant that's particularly important to that center. Maybe you have co-tenancy issues that you don't want to trip up. You may want to hang back a little bit and leave that alone. So the approach, again, is going to be very individualized. And then if they do end up filing for bankruptcy and they're still in that space, the most important thing to do is act quickly. And unfortunately, being on the creditor side of bankruptcies, it's more like react quickly because you're not in control of anything at that point. The retailer, or it's known as the debtor in bankruptcy, is really in control. They're in control of lease decisions. You can no longer go after them for pre-bankruptcy amounts owed. So you have to stop, collection or possession efforts, right in their tracks as soon as they file. And then they'll often have, could be a dozen or so filings that they hit on the first day of their case. And there's going to be a court hearing on those, which affect generally landlords, other creditors, substantive rights It could be on that same day or the day after, usually within 24 hours. So these go really, really quickly, especially at the beginning, and they're important to understand right away, what's going on.
What's the time period typically between when there is a filing and when the actual court date happens? How long is that period?
Yeah, it could be a day or two.
Wow. Okay, that's
And
what you're referencing.
it often goes from a Sunday to a Monday.
Okay.
Yeah.
So if you have any inkling, right, or you see anything in the news that your tenant is filing or contemplating filing, it's go time. That's what you were
exactly
right at the
and
beginning.
That's why
there.
it's good to be prepared ahead of time, right? To know maybe you have several different properties with this retailer as the tenant, right? So you have to go through that analysis beforehand. If they file, what's going to be our goal at this premises, right? Do we want them to leave, right? To reject the lease? Do we really desperately want to keep them? Or maybe we can go either way and we'll see how the negotiations go. So yeah, that preparation is super important.
And it sounds like that would be a great proactive discussion before they file or before you hear of any inklings of filing, just if you think some of your tenants might be struggling, almost like an emergency action plan, what to do if this does in fact go that route. So I'm sure you spend a lot of time advising clients on plans that they hopefully never have to put into action.
Yes, we do try to, but I will say often a lot of landlords tend to sort of think about it on the back burner, right? Unless there's a specific tenant or a specific property that's really going to give them a lot of heartburn. A lot of times they'll consider it, right, for certain reasons, but not always do something about it. But it can be really useful. You could avoid a potential whole bankruptcy mess, right, if you do a lease termination beforehand, and then you lose your exposure completely. It could really save yourself a lot of hassle.
Interesting. Now, I know there's a few different filing classifications, Chapter 7, Chapter 11. I believe there's a few others. Talk to me about the differences of the filing designation and how that would affect a landlord's actions.
Yeah, no problem. So there's Chapter 7, which is just a straight liquidation, right? So that's when a retailer may say, we're just going out of business, right? We tried other things. They didn't work. We're giving up. We're done. So when you file Chapter 7, there's a trustee who gets essentially appointed and comes in, and they become in control of that retailer. So you can no longer go to that retailer, ask them to pay current rent, anything like that. Everything goes through that Chapter 7 trustee, and that would usually lead to immediate store closures unless there's an exceptional circumstance, which they could try to monetize a lease. But generally speaking, that's it, lights out pretty soon. Chapter 11, which is the much more common route to go for retailers really of any size. You could use that as a vehicle for any outcome. You could actually liquidate through a Chapter 11, and more common is to use it as a sale or to use it as a reorganization. So something like Party City, right? They came into bankruptcy hoping that they could stick around with maybe a little smaller footprint, do some lease amendments, change their corporate structure. And they've managed to now just come out after a little bit of a long haul, in bankruptcy since January and reorganize. And they're still Party City, operating essentially the same business. Then you have a sale situation like in David's Bridal recently, right? Mm-hmm. They came into bankruptcy sort of just hoping to survive in some fashion. They ran a sale process that could involve, bidding, auction, so forth. There ended up being one potential buyer, and they took over David's Bridal, and a lot of the leases are now in the process of going over a new company. And then you have, again, liquidations where a retailer comes in, they end up sort of closing most of their stores. Even Bed Bath & Beyond, had a large component of that, right? They tried to do a potential sale, didn't really work. They just sold their IP. So they either sold a lot of their leases, as you know, to other retailers in an interesting lease auction process. And then a lot of stores, they just closed and just aren't in those centers anymore.
Yeah. that was very interesting. We've touched on that and with other interviews. The frenzy that was the Bed Bath & Beyond lease auction
Yeah.
was pretty fascinating. And that kind of leads us into our next question. What are retailers' options with their leases if they're facing bankruptcy? We just touched on it high level, but is there anything else you'd like to point out beyond just the potential auction process?
Right. So an auction, a sale, right? Those are all vehicles to sort of do things with their leases, these retailers. But overall, they have three options. They can assume a lease, which essentially just means retain it, right? Like a la Party City in a reorganization. They can assign a lease, right? Like in David's Bridal with that sale situation where it goes to a new entity, and a landlord there will have to look out for how's this new entity going to perform under the lease? Are they adequately capitalized? Can they perform under the current terms of the lease? Or do they need to be amended perhaps? And you go through that exercise. And then there's a rejection of a lease, which sort of sounds just like it is. It's similar to a termination outside of bankruptcy. And essentially it just means we don't want to be in this lease anymore. No one else seems to want this lease. We're getting out, and then we no longer have to pay anything under it essentially after that date.
Interesting. Now, often when a retailer is facing bankruptcy, there are late or deferred rent payments. Right. What happens to all of these arrears under those different scenarios?
Yeah, so if they're considered pre-bankruptcy amounts, and that can be a whole different conversation, but I'll keep it general. Pre-bankruptcy amounts don't have to get paid unless the retailer wants to either keep that lease, right, to assume it, or if they want to assign it to somebody else, right? If the lease stays alive somehow, those arrears need to be cured, right? They need to be paid unless a landlord agrees otherwise, right? Perhaps the landlord is really interested in keeping this tenant at the center, again, co-tenancy issues, anything else. They may say, all right, we'll take a discount on the arrears, or we'll waive the arrears entirely, to facilitate that. But if a lease is rejected, as I was just alluding to, they don't have to pay those arrears at all. And all the landlord is left with is like what's called a claim, right? You can file something in the bankruptcy case that says we are owed this amount for pre-bankruptcy arrears. And then you can file a claim for what's called rejection damages, which is essentially either 1 year or 15% of the remaining lease term. But those claims could either be worthless or perhaps get paid pennies on the dollar a lot of the time. So it's a pretty big difference when you think about the outcomes.
And does it matter? It sounds like no, how much in default the retailer is on their rent payments, if it's 2 months or 6 months. Is there any differential treatment based on the timeline or amount of the arrears?
No, there's no difference at all. It could be $5 or $5 million. It's the same deal. It's if it's considered pre-bankruptcy, right, which can differ by court even, right? So Bed Bath David's Bridal, they filed in New Jersey. They go by a certain method of determining what's pre-bankruptcy versus post-bankruptcy. Then you have a case in Florida, for example, Steinmark filed there a couple of years back. They have totally different rules as to what's considered pre-bankruptcy or post-bankruptcy, right? So going back to your sort of deferral type question, right? That was certainly popularized a few years ago. So a lot of those payments have been coming due in recent bankruptcy cases. So it's been a challenge for landlords to understand how that interplay works with the bankruptcy. And that's something that we look into quite often and have advised plenty of people on.
Yeah, that just adds another layer of complexity if you're dealing with deferrals. It's not even that they're just late on their current payments. It could be past COVID deferrals that are now being paid as well. Very interesting. So what advice then, with all this in mind, do you have for landlords if the tenant starts becoming late on their rent? How big of a red flag is 1 month, 2 months, and what steps should they take to try to get ahead of this?
Yeah, I think it's helpful at that point, as soon as they're 1 month late, even just to be in that information gathering stage, right? Whether it's talking to your contact at that retailer, whether it's talking to other maybe shopping center owners or managers, getting a sense of, right, is this happening across the board, or is it just us at this location? because sometimes retailers will have their own reasons for paying certain, rent over another. But a lot of times it will be tied to a pre-bankruptcy strategy. For example, Party City came into bankruptcy having paid some of their January rent, for example. They filed in the middle of the month. You'd normally think, well, why would they pay that, right? It's a pre-bankruptcy amount, right? It came due first, let's say. They didn't want to get locked out of certain locations, right? Like in Texas, it's easy to do a lockout if you're a landlord with a retailer who's paying late rent. So they strategically paid rent in certain geographic areas based on the laws,
Right.
and didn't pay rent in other areas. So it can be as something, as simple as that. And it could just be an overall strategy. So it's important to get that information gathering going right away, because if you don't start right then, it could be too late.
So first month that they are late, it's time to take action.
Right.
Not wait and hope that the next month is better. That is the message to everybody listening today. Take action.
Yeah, and we get that question all the time, right? I'll have a landlord contact send me a note and say, hey, have you heard anything about, X, Y, or Z? They haven't paid, at 2 of our locations. And then maybe I have heard something already, or if not, I'll canvas, our other clients and contacts in the industry and see sort of what's been going on, with them. And I get in that information gathering stage right at that point.
Right.
This is something I would do, if you read a rumor about, a company filing, you talk to someone in the right place. So yeah, it's critical to be thinking about that.
Knowledge is power, for sure. Definitely would drive the next steps. So any interesting, or I don't know how interesting bankruptcy is, any unfortunate retailer bankruptcies that you've heard about that you can speak of that maybe we on the outside are not aware of yet?
Yeah, I mean, I think as I was, going through this process recently, just advising someone on who they should be on the lookout for. And then I was ticking through some names, the names I would say that are coming up. Well, Rite Aid has been sort of public with that, right? The opioid litigation has sort of fueled this need for them to file, but they've been on a watch list of sorts for us for a while. They seem to just not be as into their retail operations as they used to be, and looking to cut back on the portfolio a bit. Then you have, some sort of furniture related stores. You have At Home, Big Lots. Both of those have been in pretty serious trouble recently, so wouldn't be surprised to see them coming our way. Joanne, same sort of situation. You think about those names, especially the last 3, and you think maybe, is that a sort of a COVID related trend? It seems like it is, right? Those sort of marketplaces were popularized, right? When everyone was home, people were buying furniture for their houses, they were crafting at home. And it was tough, right, with that. So they ramped up, got a bunch of inventory in, and then it was hard to figure out when to cut back, right? When would that trend stop? When would it slow down at least? And if you didn't manage that, exactly right, it could have been, devastating. And I think for a few retailers, that's what's going to happen. Their cash flow is just not the same as what it was a couple of years ago. So there are a few of the names that may be in trouble, but are, I think, emblematic of that trend of, this, I guess, COVID-induced, right, upswing and downswing that we may not see in a typical market.
So interesting how that was just situational, right? Maybe they were very well run, great companies, great business lines. It's just unusual circumstances in their client base that caused such a peak and then such a trough. Very interesting. We'll be watching how they come through. Thanks for putting those on our radar.
Yeah.
Have there been any changes, speaking of COVID, to leases in the last few years that would affect landlords' rights, or things that landlords should be especially paying attention to in lease clauses in terms of potential future bankruptcy concerns?
Right. Well, we touched on this earlier, right, with the deferrals. So that's come into play, right, in the bankruptcy context and outside of the bankruptcy context, frankly. And it's been a big, I think, driver of certain bankruptcies that have been filed, because if, you're about to owe, 2 years of deferral payments coming up and you don't quite have the liquidity for that anymore, file for bankruptcy. And then you have those options we talked about, right? You could reject the lease, get rid of it, and you're off the hook essentially on future payments. Again, landlord has a claim, but who knows what that's worth. So that's been a big factor. There was a lot of talk of, the force majeure and all those sort of lease clauses at the time. I haven't heard too much about that recently because I don't think people feel like those are going to maybe come into play again, but they did get a strong look, during, 2-3 years ago. I think some of those have been changed and streamlined a bit. And then otherwise, I think just more of a general retail trend of leases and sort of operations from a retail perspective, right? How are they using their space? So you've seen some leases take into account, maybe they're going to decrease the retail floor space and increase sort of the back room, right? They're going to use that as a mini fulfillment center. So it's sometimes in the lease, sometimes not, but there's been that shift that we've seen as well.
All very interesting points. And again, just because of the unique history we've had over the last few years, fascinating to see how those circumstances have translated into real-time legal changes in these leases. And I do feel that we have a bit of a short memory, to your point, on force majeure, which was everyone was talking about. Now we're like, that's probably not going to happen again. I don't know. Do we need to be so worried about this? So hopefully it doesn't. But it's amazing how that was such a hot topic, and now it's really been fading, to your point. Yeah, interesting. Is there any other common misconception about bankruptcy law or your profession in general that you'd like to share?
Yeah, I guess something we were just touching on, right? I think it's a misconception that bankruptcy is always a bad thing, right? Sometimes it's not. For a retailer, from their perspective, right, it allows them to sort of refresh their entire lease portfolio in a way that would just not be possible outside of bankruptcy, right? As we say, once they file, all collection or eviction actions have to stop right on the spot, and they have all these options with their leases about what they can do with them. And landlords work with retailers who they trust will come out of it and be successful going forward with maybe either a slightly different business model, different portfolio, reduced count, et cetera. So there's been, I think people hear bankruptcy and they say, ooh, that's terrible for everyone. And it can be a tough thing to deal with, but it also can be a good thing, again, for those retailers. And also just from the retail industry perspective, there's just going to be turnover sometimes, right? It's not always that a retailer is, bad at their, what they're selling, right? They could have a good business that just sort of isn't on trend anymore, right? It doesn't work in shopping centers anymore for whatever reason. And there needs to be a way to sort of refresh these shopping centers, especially without, a lot of development or redevelopment these days, with the way the markets are, just sort of general trend of a lack of new shopping centers over the last, probably 15 or 20 years or so. So it allows for sort of quicker turnover. That's another thing. And also for the possibility of landlords being able to use the bankruptcy process potentially to their advantage. You saw in Bed Bath & Beyond, for example, a lot of landlords attended, the lease auction with the hope of getting their space back. They're willing to pay top dollar just to get essentially a lease termination so that they could turn that space into something else and, increase their rent that they get at that space, threefold. So it can, while it's not always a good thing, there are plenty of good opportunities sort of from the industry perspective within that.
What a unique perspective. I love that you framed it that way. It's true. It's a tool, and you can be on the good side or the bad side of that tool. But my takeaway from today is be prepared as a landlord, and there are options if you act quickly and are strategic. Instead of it just being doom and gloom, which is great. Any final words of advice or anything else you'd like to share before we wrap up today's episode?
Yeah, I think it would just be that from a landlord perspective, whether you're a shopping center owner, manager, single tenant, whatever it is, think about bankruptcy right before it happens. Think about what your strategy might be with your centers, especially if it's a sort of multi-tenant, right, exposure in your portfolio. Because once they file, you're not going to have really any opportunity to do something about it right away. And if you just start thinking about it, then you lose the chance of maybe avoiding that exposure or mitigating it beforehand. So think about it from that perspective. There's also plenty of ways to build better lease provisions in that'll help you in a bankruptcy. So for example, when we deal with a lease assignment or an assumption, right, the lease is sticking around in some capacity and those arrears have to get paid, if the lease provides for it, we can get an attorney's fees reimbursement as part of that payment of arrears. But if the lease says there are no attorney's fees permitted as a reimbursement in there, we may be out of luck in there. So you could be getting a full refund of our services from the retailer that you do business with if a lease is drawn up the right way on that provision. And there's several others that could be helpful in this context as well. So it's another reason to be thinking about this, before it happens.
And those are things no one thinks about until they're in that crisis moment going, oh, now what?
Exactly.
Right. So just like you said, this whole episode, preparation is key, gives you options and usually a better outcome. So the thinking about the lease provisions is just another piece even earlier in the process when you're certain there will be no problem with your tenant, or why would you be signing the lease? But again, always good to be prepared for the what ifs. Yes. Scott, this was great information. We really appreciate all of these insights, things to think about, really tangible advice for our landlords and all of our listeners. Thank you so much for your time today.
Thanks, Karly. It was great to be here.
To everyone listening, that was Secret Sauce. We're happy you could tune in, and we will see you again very soon. Have a great day, everyone.